I went to a really interesting discussion with just people who work on transparency reports, like the aggregate data reports of the number of removals per policy, et cetera. And they were so dispirited. Their question was like, why are we doing this? Who uses these transparency reports? Like, we really want to feel like our work has value for someone. How can we structure this to actually be useful and not just be a box checking exercise? I think in a way, it's on regulators to look at what they're requiring and try to only require useful things. But in a way, that information should also come from trust and safety people, because they're the one who can look at the data and say, actually, we're seeing this other thing that's worthy of discussion that's not captured in your categories. And what if we were allowed to allocate resources to transparency about that other thing instead of the 80 other categories you told us to track before?
Welcome to Anchor Change, where we help you panic responsibly in a chaotic world. I'm Katie Harbath. I've navigated impossible trade-offs in tech, politics, and my personal life for decades. I know that can be lonely. As a Midwesterner who spent 20 years in Silicon Valley and DC, it's taken me a while to figure it out. I still am. One thing that helps me is hearing the stories of other people forging their own paths. Because in a world of complexity, you don't have to navigate it alone. Welcome to Anchor Change. Welcome to Anchor Change. I'm your host, Katie Harbath. Today we have Daphne Keller, who's the Director of Platform Regulation at Stanford University. Daphne is one of the premier scholars when it comes to tech policy and the law, not just here in the United States, but in Brazil, in Europe, all over the world. She started her career at Google and then went into academia. And so I'm excited to talk to her about everything that is happening at this dynamic intersection of tech, politics, and law, what we are seeing happening here in Washington, D.C., but also abroad. So please enjoy. Daphne, welcome to Anchor Change.
I'm happy to be here.
Super excited to chat with you. But I want to start with a little bit of your background and history, because you've been at the center of a ton of conversations about online speech from your time at Google to now your work at Stanford. What drew you into this puzzle of how law and technology shape expression?
Well, what got me into it in the first place is super nerdy. So I'll try to talk about it really fast, which is, as an undergrad, I studied a lot of things like semiotics and like how is meaning constructed through language, blah, blah, blah. So I got to law school and discovered intellectual property law, which is also about like, what are the systems that we can create in the law to incentivize production of information? And from there, going to Google and working on web search and like organizing information and figuring out ways to channel it to people in ways that are useful, and then dealing with the systems of rules for countries making you stop doing that, kind of felt like a straight line, a nerdy straight line.
Well, and you were at Google at the very early days, right? Like, what was your time frame at Google?
I started in 2004. There were 40 lawyers at the time. They'd just done the IPO, so a lot of them were doing sort of corporate work, and it was all hands on deck all the time because there were so many products to launch and so many countries' laws to look at. So it was a super chaotic time, but it was fun because Google was willing to take these aggressive legal positions on things that I really believed in and cared about, like fair use for indexing the web, and I got to work on that. But by the time I left in 2014, there were 800 people in the legal department. And as you probably know from your time at Meta, while it was growing, you get to a point where there are a lot of stakeholders who can say no, and things are quite cumbersome.
No, but I think it's important for people to remember that there was a period in time that even a company as big as Google was quite small in trying to figure out a lot of these issues. Because I think, right now, the conversations that we have, I find people sometimes only even go back as far as 2016 versus some of those issues that really kind of stem from stuff that happened in the late 90s and early 2000s that continue to build upon all of those.
Absolutely. And I think copyright in particular hit all of these issues much sooner because there was a notice and takedown system for copyright going back to the 90s. And then, of course, there was abuse of that notice and takedown system by people who wanted to silence their critics online, or the Ecuadorian government used it to try to get rid of truthful reporting and police brutality videos. So in copyright law, all of the questions that have come up more recently for trust and safety and other areas of law got worked through, starting again in the 90s.
What are some of the things and biggest misconceptions that you continue to see about like content moderation or platform regulation that you see repeated the most often, whether it's been over the years or even most recently?
Well, so we're recording this shortly after the umpteenth jawboning hearing convened by Ted Cruz.
Yeah, that was an interesting hearing, like all.
Yeah. So there's a mistake that is made very commonly that I saw made constantly in that hearing, which is people think that if they look at one dispute about content moderation, that and they have an opinion about how it should have been resolved, that translates to having a system that a giant company like Meta or YouTube can use to moderate content at incredible scale, and it just doesn't. Our friend and colleague Dave Wilner always uses the example of the Vietnam War era photo of the girl. It's called the
Napalm Girl.
Terror of War, Napalm Girl. Facebook took it down, and then a lot of free speech advocates and newspaper editors around the world were like, "What are you doing? This is a historically important photograph, but it's also a picture of a naked and suffering child. Like, of course, that violates a bunch of policies." And the idea that just because you can have a strong and informed opinion on that one question, that translates to knowing how to have a system for answering those questions tens of thousands of times a day, is just completely unreasonable. And what
That's
we
one of
saw in this, yeah,
No, keep going.
I was going to complain about the hearing. What we
No,
saw in
please do.
this hearing was kind of an even worse version because it was convened to complain about government pressure on platforms to moderate content in particular ways. And it immediately devolved to all these members of content pressuring the platforms to moderate content in
Or to
particular ways.
apologize for moderating content, right? Like Senator Cruz is like, "Do you regret anything, Google?" And the guy is like, well,
Yeah,
yeah, we made mistakes, but like,
with just
what,
no sense of irony about what they're doing. It's stunning.
It's well, and it's you're seeing it on this is what I drives me nuts about these hearings because they could be incredibly productive if I know that's not the purpose of the hearing. The purpose of the hearing is to get the sound bites and everything that people want to do. But like if I could wave my magic wand and get senators to do what I wanted them to do, I would actually want to have a conversation about, okay, where do you draw the line? Let's show a bunch of borderline cases and walk through and have folks on both the left and the right with experts. Let's talk about where we would actually draw the line on these things instead of making it seem that it's super easy and it was just that this company made a stupid decision or they were doing it because of partisanship. Like the number of times at Facebook, I'm sure you had this too when you were at Google, people think that we have rooms of people just purposely looking for content against somebody and taking it down. And it's like, no, that's not how it works.
Honey, we're not paying that much attention to you.
No, we're not.
Yeah, but to the point about having an exercise where people just go through a bunch of hard decisions, I have experienced that being so productive. Like just to frame the beginning of a conversation for people to realize how hard it is and realize the difficulty of articulating a consistent set of rules that are going to resolve them all right. Emma Alonso formerly from CDT and Mike Masnick of TechDirt have a session they've done on that, a set of questions that I think have been really productive. And I just would love to see more conversations framed that way.
I do it for students. I get pulled in for a guest lecture and I do this 90-minute thing where I make students become content moderators. And that Napalm Girl photo is one of them. First, it's kind of interesting how many students don't realize it's a Pulitzer Prize winning photo and don't know it's a historical photo. But then, two, I actually had, it's interesting to watch them to think through that because they don't necessarily immediately go to it being a naked child and that potentially being the issue or like what all of those things are. And it's just a fascinating case of sort of like peeling back the layers of the onion that it takes
Hmm.
with all of that. And I would love for us to have more conferences where instead of talking about the theoretical, bringing it into the practical of
Hmm.
the challenges of doing content moderation and making these calls.
Yeah. I don't know who said it, but amateurs talk strategy, generals talk logistics. Like
Yeah.
logistics is everything. If you don't know how to make the logistics work, you cannot have a functioning system.
Well, let's talk about the logistics because you brought up Dave, and he recently did a talk at Berkman that I'll link to in the show notes about automating content policy and using AI in which to do that. And you post, I can't remember if it was Blue Sky, LinkedIn, or both, but you were like, gosh darn it, Dave, you've made me maybe rethink my positions on this. So, what
Mhm.
was your position? And then what about Dave's talk and his work is making you rethink that position?
Yeah, so I'm not off of it yet, but I'm open to being persuaded by Dave, although I will be irritated by that. But for years and years, lawmakers in Europe and the US, and to a lesser extent, other parts of the world, have tried to pass laws mandating that platforms use technology to detect what speech is illegal and automatically take that down. And there's a huge problem with that
Mm.
for most kinds of speech that we care about. The best case scenario for that, and the way that it really is deployed by, every responsible platform pretty much, is for child sexual abuse material where you have known content that really is illegal in every possible context. You can have hash-based systems that detect duplicates of images that are already identified, or you can go beyond that and try to detect new images. Like that is the most credible deployment of automated content filtering. But if you try to do that for defamation and automatically detect what's true or not true, or to take an image that is illegal in one context because, for example, it is ISIS recruitment material. If you filter automatically for that, the filters are blind to context. And so, as is quite well documented, research organizations, anti-radicalization organizations, teaching, like all of these ways, news reporting in which the same content gets deployed in a new context that makes it legal, those are vulnerable to being silenced by automated content detection tools. And this is something that in Europe really came to a head around copyright and then around the proposed terrorist content regulation, where they were going to try to mandate that platforms deploy filters that were going to automatically know which instance of an ISIS recruitment video was used in scholarship, and those filters don't exist. And they wound up not enacting it because they heard from three different human rights officials opposing it, just a cavalcade of global free expression organizations opposing it. So far, I really don't believe we have the technology that would make it okay for a government to say, go forth and, have the robots decide what's illegal. But Dave's been working on this with his Zentropy, his company, this machine learning model that is relatively lightweight, can be deployed from a laptop, and that is quite good at enforcing content moderation policies of the sort that platforms voluntarily enforce. And that does seem like a technology that, it's never going to know what's true. So it can't tell what's
Yeah, it's not going to be
defamatory,
able to do that.
but
Yeah.
but it might be able to detect, what is hate speech under German law. Maybe there is actually a future like that. It scares me as a civil libertarian. It scares me, and I kind of don't want it to be true, but I also don't want to dig in my heels as the technology evolves around me.
What I also find interesting with what Samit and Dave Wilner, Samit Chakrabarty is Dave's partner on a lot of this, is that it's not just using AI to try to find the material, but it's also using AI to write better policies that
Hmm.
are more clear for that, which is, I think, something going back to that hearing and common misconceptions or in the public is that, oh, you have a policy, then even whether it's human or robot are going to be able to clearly interpret that policy based upon what it is that should or should not be allowed. And like earlier this week, I was at another company and they have a demo of doing content moderation. I like to think that I thought I was pretty good. I got both of them wrong because I got them in my head, and how different companies interpret different policies mean different things of what's allowed. But I think that, again, having more people talk about the I can't say the word operational, people know what I'm trying to say. Um, Around all of this is an important component of that. And you must, because you're kind of at that intersection too of like, okay, the law says this, but the law's never super specific of what
Hmm.
is or is not in compliance, right? Like,
Hmm.
how are you seeing those things collide?
It's kind of funny. So in the US and in other common law countries like the UK, we have the law that's written, in statutes by Congress or state legislatures, but then we also have, in many cases, decades and decades of court interpretation that have refined it and that, tell us how it applies in a particular situation or how to interpret the law in a way that protects the First Amendment, like for defamation, having it be harder to succeed in a defamation case against a public figure. But in civil law countries like France, the theory is that the law is what is on the books. And while a court with a new case might look at what previous courts did in interpreting the same law, they don't have to. The real source of truth is the law in the books. And if you look at like the French civil code, it is quite imprecise. It is, I think, far more imprecise than Facebook's published content policies. So there's a little bit of an inconsistency in saying to me that private companies need to be ever more and more and more specific about their rules, while governments whose power over speech is so much greater and carries the weight of fines or jail or serious life-altering punishment, they don't have to be that specific.
Well, let's stay on the compliance part because you've got a great piece in Lawfare that I will also link to about trust and safety work that is continuing to go through many evolutions in its work, but particularly how, as more laws are passed in places like Europe, Australia, the UK, Brazil, etc., trust and safety is becoming a compliance function, meaning it is spending more time satisfying regulators than necessarily what is best for users or public discourse. Can you talk through that evolution a little bit and how far down the road we are on that?
Sure. So that piece, I got more positive feedback about it than anything I've ever written.
I think it was cited in like all across TrustCon. It was the piece of TrustCon in July that everyone was talking about.
Someone asked me for a signed copy.
Oh, that's cute.
It's wonderful.
You're a celebrity in the trust and safety
in this
field.
very niche community. Yeah. But it's also a piece where I feel like, I was bringing my nerdy analysis, but I was kind of just reporting like,
Yeah.
hey, world, here is what trust and safety people are experiencing. And so then the trust and safety people who read it felt seen and they were like, thank God somebody's describing this. But the shift is, in the very earliest days of content moderation, going back to, like eBay and Yahoo were encountering these things in the 90s. It was artisanal, would get an individual case and smart, thoughtful people would sit down and try hard to make the right judgment in that case and eventually there was just much more attention and thought and care given to any given decision. And that becomes impossible at a certain scale. And so it's partly just the way that platforms evolved that made that artisanal thing not possible and made content moderation have to be a big, like a factory-like system almost. So I don't want to blame regulators too much. They would say, platforms, you're the ones who made this industrial scale speech management have to happen. But laws like the Digital Services Act in the EU and the UK Online Safety Act and the law in Singapore passed last year, those I think just ramp up the amount of form over function or the amount of time spent explaining the design of content moderation tools, auditing the design, documenting that decisions were made by the right people and escalated to the right people, tracking, vast amounts of information for transparency reporting or for this amazing database that the EU has built where every single content moderation decision made by platforms that led to a notice to the user, which is almost all of them, they also have to CC the European Commission. And so it goes in this database and there's 17 fields. It's just like the amount of tracking and weighty process is phenomenal. And I worried first about the trade-offs of that for competition, because it's not just the biggest platforms who have to do it. The smallest platforms are having, at a stage where Meta or Google were, growing easily and didn't have to hire 1,000 compliance professionals. The smaller companies are running into this huge drag. and it's going to make it much harder for them to compete. But there's also a question of like, how is this going to affect the actual substantive speech decisions made by any of these platforms? And I'm sure you hear this all the time too, that people in trust and safety say we're spending all of our time documenting what we do instead of doing what we do. And, the time to actually accomplish what we are there to do is whittled down, and we're afraid we're going to do worse jobs. I went to a really interesting discussion with just people who work on transparency reports, like the aggregate data reports of the number of removals per policy, et cetera. And they were so dispirited. Their question was like, why are we doing this? Who uses these transparency reports? Like, we really want to feel like our work has value for someone. How can we structure this to actually be useful and not just be a box checking exercise? I think it's, in a way, it's on regulators to look at what they're requiring and try to only require useful things. But in a way, that information should also come from trust and safety people, because they're the one who can look at the data and say, actually, we're seeing this other thing that's worthy of discussion that's not captured in your categories. And what if we were allowed to allocate resources to transparency about that other thing instead of the 80 other categories you told us to track before?
Well, and what's interesting too when I talk to folks is there's not only that question of like, why are we spending all this time? Is it actually being helpful? But then also that they're like, so for instance, last year when all these elections were happening at the same time, they're like, I have to focus on, let's say, the EU elections because there's all these requirements under the DSA. And that means I'm spending less time on the South African elections because I don't have regulatory requirements there. But in the grand scheme of things, there's actually probably more problems happening in South America or South Africa that I should be paying attention to, but I can't because of the regulatory requirements. And so I understand why countries or regions like the EU aren't necessarily going to be like, oh, I'm not going to help you prioritize because they, in their mind, I think they're like, you have all this money. But to your point, that was a big, well-resourced company, let alone a smaller company that has one or two people who are trying to figure this out across a ton of different brands and are just look like deer in the headlights. I just want to give them a big hug because it's
Oh my
like,
God. Yes.
and they're like, you're not being clear, and they're fighting engineers who are like, just tell me what I have to do. And then the policy folks are like, well, we don't quite know. We need to do
It's a
it and see
balancing exercise.
if Ofcom yells at us or not. And then like, we'll have to come back. And then they're like, well, are we going to put all this time and effort in building something? And then they're going to tell us it's not good enough. And it's like, maybe,
Yeah.
but
Yeah.
that's
Which
what we have to do.
definitely happened with the DSA. There were a bunch of things where compliance was due at, I think it was August of 2023. And then guidelines on how to do the thing came out 6 months or 12 months later. And then companies had to go back and re-engineer, redesign a whole system. The other thing a lot of them are running into is, you have to give users notice about a content moderation action in a bunch of different countries, but the fields of the specific items of information that go in there are different in different countries, or same things with transparency reports. There's just slightly different criteria. So then there's all this redundant work to take the same information and like slice and dice it slightly differently.
I
There's
am
yeah.
Well, I'm also seeing a lot where this is really changing the org chart when you think of trust and safety and this work, where we are now starting to see roles that I don't think existed before, which is sort of like it's in the product org, but it's about regulatory compliance or trying to get ahead of regulatory compliance, which is new because it used to be like when I was at Facebook, I was on the public policy side and I always kind of was like, I'm the political advisor to product teams and how to figure out how to do this. And now the product teams are kind of like, no, we want to have our own people in addition to our government relations people and stuff like that to help us to think about this. Are you seeing similar sort of org chart and what things happening inside these companies to try to figure out how to deal with all this?
I don't think I'm close enough to see the org chart changes, but I do just like to tie this to the job owning hearing this morning. Your former colleague and mine, Alex Stamos, used to always say that he thought a problem within Facebook was that the team that did content moderation and the government facing public policy team that maybe wanted to maintain good relations with people in government reported up into the same organization. And he thought it was really important for those things to be separated so that it's harder for influence to flow from the government to the content moderation decisions. And I always had a little bit of hesitation about that because
I don't agree with
ultimately
him, but I
they're
want to hear your
the
side
same.
first, and then I'll share mine.
Yeah. Well, I mean, ultimately, they're all going to hit the same apex decision maker at the
Yep.
CEO. And so does it matter? I mean, there's some like maybe friction effect where some things will get resolved at a within the team level and fewer things will get escalated. But I'm not sure about that org chart, Paul.
My
I'm
full point
curious
of view.
your take.
Well, my point, it's the same thing. My point of view is separate them, don't separate them. It doesn't change the fact that the CEO of the company and other senior leadership are taking political considerations into account when they make these decisions. And so to me, that's the conversation that I think we should have about the real, like, I was not doing my job at Facebook if I did not tell people what the political ramifications of the
Hmm.
decision would be. That was my job because that was going to happen. And the worst thing I could have happen is I don't tell them that. And then all of a sudden they're like, wait, why am I having to go testify to this hearing? Why didn't you tell me that this is what was going to happen as part of all of that? And so I think it's not a reality that you can escape as much as people would love to not have politics be a part of it. But the question is, how much should it be? How much, where should that be in the stack rank of everything else that you are trying to decide? And how much can you actually weather when it comes to the jawboning on from all sides of the aisle and ref working of trying to get you at, because at the end of the day, they're just trying to, they want these platforms to be more beneficial to their side, to the messages they're trying to get out. And so it's an impossible situation that the companies find themselves
Yeah.
in.
I mean, it's so clear how much politicians on each side want to influence platforms into setting the rules that those politicians want. And there's no good guy here. I mean, there is no greater pro free speech disposition on the right than the left, in my experience. It's, everybody wants to shape the conversation to their own preferred set of speech rules. Going back to the organizational thing, so Katie, I imagine you were the good kind of public policy person, which
I
is the
try.
one who comes in and says, if we do this, these are some possible consequences, and like here are things we could do to avoid them, whatever, lays out the landscape, which is exactly the right job. And then you figure out with the other stakeholders internally what the right call is. But I think there's an unavoidable incentive for public policy people whose job depends on ongoing good relationships with people in power to want to accommodate the people in power in DC or Brussels or wherever. And so it's really important, I think, for those people to be able to separate, like, no, sometimes my job is to tell them to go pound sand. And like, I'm going to go huddle with my team and figure out what we're doing. And then I'm going to do that.
Well, and we did have checks and balances in there. Like we purposely set up processes so that when a member of Congress would call up our government relations team and complain about something, the government relations person was not making the final call. Like they were
Hmm.
sending it on. We had a process in place for somebody else to make the decision, and then we would circle back. And then oftentimes, then I would offer to the government relations person, I will go to that office with you and I will explain the decision. So it doesn't have to come out of your mouth.
Hmm.
You can kind of be like, listen, I passed it on, but that's not my job. This is the reasoning why. I mean, you're still, the company is getting yelled at, but
Yeah.
you try to find ways to, like, there was a lot of stuff where we were like, no, this is like in 2018, we took down a bunch of conservative pages, and I still have screenshots of people on the right on Twitter having my face and it said Facebook witch underneath it because I was the public face of, having worked with them and everything, but they were breaking our rules and we had given them every opportunity to stop breaking the rules and they didn't do it. And so then you have to make that tough call of being like, this is the right thing to do, even though I'm going to get yelled at by these people.
Yeah, you got the public brunt of that much worse than I did because I had that same bad guy role inside the company of being like, nope, I'm going to make you go say no to this person who's going to be unhappy. And if you want, I'll show up and say no for you. But like, you're not giving them what they want. But that was mostly in, with governments. And, it just it wasn't a focal point of public attention the way that it was by the time you were doing it.
Now, what is interesting though that's happening too, particularly with the Trump administration here in their second term, is that I think we are seeing companies starting to push back a bit more on some of the regulatory requirements and everything like that. And utilizing political power in a different way that I have not seen before, particularly pushing back against Europe on different things. Are you starting to see, like, do you suspect that companies will start pushing back even more on how much it costs to comply with these regulations and how much time, money, and effort that they're putting into them?
I mean, my theory of what the big platforms want to be different in Europe is that there are some regulations that really hit their bottom line or really impede their choices about their business model. And it's not the speech regulations that do that. It's the Digital Markets Act in Europe, which is a competition regulation requiring things like interoperability that has made, for example, Apple very, very unhappy, and the GDPR, the big data protection and privacy regulation, which makes it so there are, revenue models you cannot pursue, or service interoperation models that data sharing that you cannot pursue. I think those things are much more existential for the platforms. And so even though we hear a lot of noise and public complaining about the Digital Services Act, which is the content moderation compliance speech law, I think that's a front. Like I think they don't like it. They don't like the compliance cost. They don't like having choices taken out of their hands. Of course, they don't love that law, but plenty of platforms, definitely including Meta, had kind of bought in years in advance to the idea that this is what's going to happen, and we just want to shape this kind of a regulatory, being regulated like a factory type law as best we can. Like that's been baked into what they knew was going to happen for years and years. So I think it is politically expedient right now to complain about European speech laws because it gets a lot of traction with the administration, and it's an easy thing to get attention for in public. It's fun to complain about censorship, but what they really want from the US government is help getting out from under these more boring but super important competition and privacy laws.
So recently, the EU did find that TikTok and Meta were not compliant with DSA transparency rules, which we sort of expected. It seems like kind of symbolic, like EU showing that they're trying to take action and stuff like that. Do you think that, like, do those things matter? Like, is that going to change, or is this all part of the dance that everyone's playing in Europe right now?
I think it does matter. And the transparency rule that they were talking about in those preliminary findings is one I care about a lot. It's the one that lets researchers scrape data from platforms and like do just the super basic ground level research where you look at what platforms are actually showing people and do research based on that. So I'm personally glad they're prioritizing that. But I think the big heavy question people are waiting on with DSA compliance is what's going to happen with X. Because I think if there are more advancements and more aggressive action against X, that might trigger more retaliation from the US than moving forward on these earlier stage decisions against Meta and particularly TikTok. So yeah, there's a lot that I like about the DSA and a lot that I don't like about the DSA. Like, I'm glad to see enforcement moving forward. It would be discouraging to me if sort of bullying from the US administration in partnership with US platforms made them back off of enforcing a law that was passed through a democratic process and like is accountable to courts if it infringes on free expression. They passed the law. I think they should move forward on enforcing it. And I'm glad that they're not sort of paralyzed.
Well, speaking of US bullying, let's move to Brazil because we hear a lot of people talk about Europe, but you and I are two people that I know keep a very close eye of what's happening in Brazil, where the US has taken some very extraordinary measures against the Supreme Court Justice Moraes, right? Am I getting that right?
I think it's Demarais,
Okay.
but don't listen to me.
Who has some extraordinary powers under Brazilian law in which to unilaterally tell companies to take stuff down or not. But Brazil's become a very interesting test case for platform regulation around this info, elections, the judicial authority. Can you give folks a little recap of kind of what the current standoff is between Brazil and the US and tech companies? And then I kind of want to analyze it a little bit.
Well, so there are a couple of different intersecting standoffs. So I'll do the parts that I follow, and if I miss anything, you
I can
should
add
you
in.
should plug
Yeah.
it in. But Brazil had January 7th was their January 6th. They had a moment of insurrection and people storming the Capitol building and storming the Supreme Court building, which had the same kind of earthquake effect in Brazilian politics that ours did. And so previously there had been a relatively broad coalition of civil society groups and experts and so forth in Brazil who were concerned about online speech and wanted to have a lighter hand in regulating platforms in order to be sure that ordinary people could speak freely on the internet. And after that, and after some specific instances of like really horrible speech that affected people in Brazil on the internet, that really shifted toward there being a lot more people willing to take the gloves off, have the government have a lot of powers against platforms, and in particular, empower Justice de Moraes to take this role that really would not exist in our legal system. And I've heard very different opinions from Brazilians about whether it's appropriate in their legal system, but where he can initiate investigations into platform issues. I believe he is the initiator and it doesn't come up necessarily through courts. And then decide what an order should be, and he's issuing orders that include extraterritorial takedown mandates, so requiring global removal of speech that's probably legal here, but illegal in Brazil. And then if the platforms so the affected person doesn't know, they can't challenge it. And if the platforms disagree, they can challenge it. But the appeal is like Justice de Moraes' colleagues. It's sort of not going through these processes. So multiple platforms are frustrated by that. X had a particular, highly publicized conflict where ultimately they wound up coming into compliance, as I understand it, because Brazil threatened to fine them by taking money out of Starlink in
Oh, yeah,
Brazil.
that's right. Yeah.
Yeah.
They
But
went
there've
after
also
Elon's
been
other properties.
yeah, yeah, innovative. But there've also been, Trump Media and Rumble tried to sue Justice de Moraes in a U.S. court, trying to get a U.S. court to order him to stop doing his job as a Supreme Court justice in Brazil. There've been a lot of sort of moves legally. There's actually a recent interesting Google case that's not quite about Justice de Moraes, but there's an airline, LATAM Air, that's based in Brazil that got a Brazilian court order telling YouTube to take down a video that they said was defamatory. And it's a video of a kid saying that he was abused by flight attendants or by personnel on the airline, which might well be, who knows if that's defamatory, but it's important public information
Yeah.
if it's true. And YouTube took them to court in California and said, we want an order to prevent this airline from trying to enforce a global takedown from Brazil. And the California court said, okay, yeah, they can't try to enforce that here. So that, there are a lot of side skirmishes that are legally very interesting, but then a lot of it ties to tariffs. Maybe you can step in here on the tariff part.
Well, because there's the tariffs part, which is, raising the percentage of how much Americans have to pay if you're bringing in Brazilian imports, which actually is really hitting a lot of small businesses in different ways that you wouldn't think about, of like things coming in from Brazil that people hadn't thought about. But then there was also the visa issue where the U.S., just like they did for people in Europe, saying that folks from like De Moraes and others in Brazil cannot come into the United States around all of that. And so there's it's a geopolitical kaleidoscope happening of different aspects that are all being different pressure points that not just the administration, but the tech companies are putting on different places in Brazil. And then Brazil also, that is a very litigious country it is very easy to bring lawsuits. And, and I heard from journalists during the election 3 years ago about how they would have so many people trying to bring lawsuits against them in the same way in the US where academics are being FOIA'd to death, for instance, and being buried by that. Journalists and others are being buried by judicial proceedings, and they can't necessarily fight them. And with how fast it can go as well. And so all of these things are kind of colliding in a way that is very unprecedented for companies to try to figure out how they're supposed to act and who they're supposed to listen to based upon where they're based versus like what might be happening in that country.
Yeah. So as when I talk to lawyers for smaller platforms, if they come to me looking for foreign counsel, it's always Brazil first and then usually Turkey second. But there's just so much litigation in Brazil.
We had to hire during election
landscape.
season. We had to hire hundreds of extra lawyers at law firms to help us to handle how quickly all of that went. And then this is my other favorite thing to do. We were talking about the simulations with students, and take it to the point where somebody gets arrested from a platform for not taking a certain act, and students be like, that can happen. And I'm like,
Yeah.
can, and it
Happened to
did
both our companies.
in Brazil, where
Yeah.
a judge has that power. And it was like, for us, it was WhatsApp. And it's like, WhatsApp's like, literally, like, we cannot give you the information you want. And the judge was like, I don't care. I think you're lying. I'm going to arrest your country head
Yeah.
until
And it's
this gets figured
it's
out.
an ad sales rep, it's somebody who had nothing to do with the decision. Yeah.
I always like asking people in that situation, I'm like, are you willing to send your colleague, not you, but your colleague to jail
Hmm.
to stand up for the thing that you think is the right thing to do? Or like, and that's usually where I start to get people being like, oh shoot, that's a lot harder. Like, I don't
Yeah.
know if I'm willing to have that.
Yeah, it's what makes hostage laws like the ones in India and Turkey and, in fairness, the EU so effective. The laws that say the platform has to have somebody on the ground who is the legal representative, because then there's somebody who is, whose freedom is potentially at stake if you do something the government doesn't like. Well, one more thing on Brazil before we move off of it. I'm curious what you think of this. To my mind, the complaints about European censorship there's a clear economic reason why that is happening, as we just discussed. With Brazil, it all feels very personal. Like it feels like Musk got into a macho posturing fight with De Moraes and Bolsonaro and his son, who I believe has been living in Washington, D.C. and
Yep.
doing a lot of lobbying on his behalf, have personal relationships, both with people within the government and the administration and kind of in that media ecosystem. So it just feels like there's money on the line, but it just feels like there's this personal element with Brazil that makes the geopolitics even weirder.
I think there's a personal element, but I also think too that with folks on particularly the MAGA right, after Trump won, in the first administration, I mean, not one, like WON. They were trying to go down into both Europe and Brazil to do, there were CPACs, conservative political action conferences happening. True Social was trying to get down there. Getter was trying to get down there. So there was a bunch of these new businesses that were being popped up by these folks that I
Mm,
think, so it wasn't money on behalf of the tech companies. I think it was money in sort of like that political sense. And then I do think, to your point, for particularly X, it's a very personal thing. And then I think too that there's Bolsonaro, there's so many parallels to Trump that is also that they're trying to, for like, to win, if you will, internationally, that they find that it's important from a symbolic standpoint
hmm.
around all of that. But then I also think too that for a lot of these platforms, there's so many, particularly soccer players that are super popular that are from
Uh,
Brazil that have a lot of followers that they're also wanting to be on the platform and stuff like that. And so I think there's elements of that too that are also a part of it.
interesting. Yeah.
And I think too that Brazil, very much in the same way that, I think that companies are very worried that a place like Brazil and the continent of South America or Africa or other places, they don't want them to take the European model of the internet. They don't want them to take the Chinese model of the internet. And so there's that geopolitical elements of it too, that Brazil, that given that it's the biggest country, depending upon what direction they go, the other smaller countries on that continent will likely follow their lead. And so they're trying to influence sort of, I think, more broadly as well, which is why it also becomes a big deal. And then we're not even talking about yet all the mineral stuff and mining and all of that also comes into play with all of this and what they may need in terms of rare earth metals and stuff like that to power AI.
Yeah, there's a piece of that feels very Cold War-esque, of like,
Yeah.
we care about Vietnam because we don't want them joining the communist side. Certainly in tech regulation, there's this perception of like, there's the Chinese, American, and European models, which I always kind of resist because, like, how about India? India's really big and what they're doing is kind of different.
Yeah. We don't
It's
talk enough about
reductive.
India.
Yeah.
Well, last question is sort of as we look towards 2026 and the next couple of years, what trends are you watching when it comes to online speech regulation that we should be paying attention to?
Oh gosh. Well, the biggest ones I think are obvious and anyone would give these answers. So one is anything to do with AI. So, laws about what AI generated content can be restricted, deepfakes laws like the No Fakes Act in Congress, which I think is a very, very bad law. And I have a long, nerdy article if anybody's into that kind of thing. And then separately, the evolution of AI and content moderation, like that whole body of speech related laws is going to keep moving. And then the second is child safety. In the US, we have seen all of these state laws on child safety, many of which are very poorly devised and many of which have been challenged on First Amendment grounds and struck down by lower courts in a lot of cases. So I think we will see those two things continue to move. The thing I'm personally focused on and very worried about is the sort of demise of the open web, the way that the AI gold rush has caused owners or gatekeepers who can control access to a body of data that would be valuable as training data. They want to make sure it isn't just scraped as training data without payment because they want to get a licensing payment out of this, locking down access to their content and putting it behind a login. And it's understandable how and why that is happening. But the result is, for example, the Internet Archive is no longer authorized to keep a record of Reddit. It's no longer authorized to keep a record of some newspapers, as I understand. And I, just as a person who writes a lot and wants to cite recent news stories, I find it's increasingly difficult to even find proof of a factual claim that we all know from the news 2 years ago that isn't behind a login. And so just the kind of ordinary
Yeah.
people's access to information is deteriorating rapidly. And I don't think there's a policy response to that yet that I've seen.
There's a lot of history that's being lost too. And I ran into this doing research for my book and trying to find in the early 2000s how different platforms were doing stuff around elections. And even on the Internet Archive, it necessarily wasn't there. You had to know the exact page in which you were going to look for that. And so I don't think we realize just how much history we're going to be losing for when historians want to write about this time period and what that means. History is always sort of won by whoever did win and whoever got to shape what is still on or not on the not just on the internet, but what information is pertained in the story that's being told. And so I definitely think that that's something we need to pay attention a lot more to.
Yeah.
But
Yeah. I mean, I think there's this idea that the internet never forgets, which is both false. And the fact that people think it makes it even more false because we just count on, of course, that Pulitzer Prize winning story will still be there. And it's not. And it wasn't
yeah,
necessarily stored somewhere else because we were relying on the internet to do it.
I
So,
also have this is a whole other conversation, but like even the formats in which we're saving digital things on, what happens is those continue to evolve. And if you stop having a way to access those old digital formats, like
mhm.
paper, you can go and like see, but that also deteriorates. But it's like it's a whole interesting question. But Daphne,
Give me,
thank you so
give me a
much for
stone tablet any day.
Daphne, thank you so much for joining us. This was fantastic.
Thank you so much for having me. This was really fun.
A huge thank you to Daphne for joining me. I absolutely love these discussions. And as you can tell, there are so many different aspects that when we talk about speech and speech regulation, that is really changing not only how tech companies operate, but how governments operate, how academia operates, but then also all the different geopolitical and other layers that are coming into this conversation that we've never really needed to have before. And it really is causing quite an evolution in the trust and safety industry. There are new skill sets that just there's nothing you could have been trained on for all of this to have all these different experiences and understandings to try to figure out how all of this is going to play out. But I encourage you, I've been writing about this on my Substack, anchorchange.substack.com. I'll put links to a lot of Daphne's pieces in the show notes. But until next time, thanks so much for joining us.